All right, good morning, Mr. Allen. We're going to wait until Trooper Alcock is connected to audio. It looks like he is. Trooper Alcock, if you could please turn on video footage and unmute yourself. Do you have video footage, sir?
Yes, Your Honor.
Awesome, thank you. All right, here, so we are here in 5A0111-624. We have Adam Allen here. So, sir, first of all, before we begin, I do have to just make a statement that Cowlitz County does offer a program. It's called the deferral program, where we defer making a finding and reporting anything to the Department of Licensing for 12 months if two conditions are met. First condition is that you don't have any new traffic infractions during the duration of this 12-month period. And the second one is that you pay an administrative fee. In your situation, it would be $150. It's not applicable if you have a CDL or you did this within the last 7 years, which doesn't apply to you. It looks like you could actually enter this program if you wanted to. Before we begin, I should ask, are you interested in this program at all?
No, simply because I do not believe that I was doing 92 miles an hour, and I do not believe Trooper Alcock has any proof that I was doing 90 miles an hour.
All right, great. So I'll go ahead and decline that program, sir. So I do see that you submitted a subpoena for Trooper Alcock to be present today. Service, let's see. I don't know what this documentation is, but obviously the trooper is here, so I am going to let you go ahead and call your witness as you subpoenaed him. So go ahead and begin.
Yes, sir. So you were traveling southbound in the left lane of I-5 when you came in front of me and then subsequently pulled me over and claimed that I was doing, at the scene, I believe you said that you clocked me, quote unquote, at 91 miles an hour. Is that correct?
It was 92 miles an hour, but generally speaking, as you said.
Okay, so you wrote the ticket for 92, but at the scene, you claimed you clocked me at 91. So what device did you use to clock me?
A D3 radar.
And do you have proof of that?
Yeah, it's mounted in my car. I have a front antenna.
Do you have the actual proof of clocking my vehicle going 92 miles an hour to submit to the court? I did request that, a subpoena of your device as well, and any devices that were used to document my speed. That subpoena was not issued to me.
So whenever you are utilizing a D3 radar, the readings are transitory. It's not like you lock a specific speed. As you're tracking the moving target, the speed moves up and it moves down.
So you have no...
It's not like
Please do not interrupt. If you are asking questions, you let Trooper Alcock answer.
My apologies, Your Honor.
So the readings go up and they go down. There's not a way they like lock in and you can save the reading. So when you're tracking a vehicle, let's say, as it's moving from 90 to 91 to 92 miles an hour, moves up and it moves down, it doesn't like lock in, so you can capture, maintain that reading to show to a court.
Okay, so there is no documentable proof of my speed.
Just that I've sworn on a sworn statement that you were traveling 92 miles an hour as I observed.
But you did say at the scene that you clocked me at 91 miles an hour. So we're supposed to take your sworn statement at either on the scene at 91 miles an hour, or that you then, after reviewing the ticket, which had another error where you claimed the truck was black even though it was blue. So your ticket is riddled with errors. And we're just expected to take your word that...
Mr. Allen, these are questions. You're not supposed to be making any argumentative statements or any subjective statements. You only ask questions.
Okay, so my question is, do you have any proof to show my speed at 92 miles an hour?
The proof is that I observed it, and I wrote on a sworn statement that I observed it as such.
And do you recall telling me at the scene that you clocked me at 91 miles an hour?
I don't recall specifically whether I told you 91 or 92.
Do you recall me ever passing your vehicle?
Eventually, when I moved out of the way so that you could pass me, because when I observed the speed reading, you were well behind me.
Correct. And what lane were you in traveling when you observed me from behind you, apparently doing 92 or 91 miles an hour?
Yes, like you said, I was in the left lane and you were in the center lane. You had moved from the left lane to the center lane at that high rate of speed. When I saw you speeding, activated my rear radar and obtained the speed reading.
Okay, and so I don't know how radars work, but I do know that Washington state law does require a testing of proof of the device every 2 years. Can you furnish that proof to the court that your devices have been tested and collaborated with in the last 2 years?
I don't have the exact documentation on hand, but I do on my radar. It does say it's within certification. I tested it before my shift that morning to certify it's working correctly, and I certified it after the end of my shift to make sure it was working correctly as well.
So to verify, you do not have any proof that your devices have been calibrated per the law.
Mr. Allen, to just save you some time, pursuant to RLJ 6.6, if you go to the Washington State Patrol certification of any speed measuring device, there is a 6.6 ruling that's out there. You put in the number of the radar, which in this situation is R2734. You put that into the State Patrol website. Out comes in the documentation that shows that it has been certified, shown accurate and reliable. I don't know if you did that on your end, but it does exist. Troopers do not carry that paperwork with them. It is public knowledge on a website. So he would not have that documentation with him.
Okay, and I did ask in my original subpoena for the officer to also provide the subpoena to get the devices, to subpoena the devices themselves.
Don't decide who's right just yet. One of the biggest mistakes people make in court is focusing on one tiny detail while completely missing the bigger picture. Sometimes a case turns on a single fact, and other times it's about who sounds more believable under pressure. As this hearing continues, pay close attention to how every answer changes the direction of the case. You might think you've already figured out the outcome, but there's a moment later that could completely change your opinion. Stick around, because the most important part of this hearing hasn't happened yet.
Would have provided that. So I don't understand, because
Did you subpoena? Here, let me look up your subpoena request. So your subpoena request here.
In my communication to the court?
Yes, I have it in front of me. So,
Okay.
so the first subpoena, you are requesting. Mr. Clerk, my subpoena, the documentation is not working all of a sudden. I do not know if you could please pull up the subpoena. Oh, here it is. So in your actual subpoena, sir, you only asked for the physical presence of Trooper Alcock via video conference at 9 a.m. He is here, so he has fully.
In my original request to the court, how I went about requesting that subpoena? That's
not a discovery request, though, sir. That's just you telling us that's what you're going to request. That's correspondence to me. That's not a discovery request.
So how? I guess I don't understand the difference between getting this subpoena for the officer when I requested it that way versus getting the subpoena for the device when it was requested that way.
There are two types of subpoenas. There's a subpoena for a physical person, and Trooper Alcock here, there's a subpoena ducis tecum, which is a discovery request subpoena. That is a discovery, a completely different one. But I'm now looking over what you have requested. Mr. Clerk, can you please provide that to me? Because my system is not working. I'm going to go ahead and try to pull that up again. I apologize, Trooper Alcock, for this limbo of time while I'm trying to pull everything up.
No worries.
System's not working. Can you please, I think it's the general correspondence, Mr. Clerk, where he just writes what documentation he would like submitted. And it's fine. You don't have to print it out. Can you just tell me what's on there? If you can read it, because mine shows a broken page, like if it's not loading.
Good afternoon. I'm requesting a subpoena for Officer Gregory Alcock, a written statement from the officer, as well as any and all devices used by the officer to record the alleged speed of my vehicle. I'd also like to subpoena the body cam footage from the traffic stop.
Okay, so you physically requested the devices. So you wanted him to hand over his speed measuring device?
No, I wanted the proof that I wanted the documentation of my speed. So it's my understanding, and forgive me if I'm wrong, but it is the state's requirement of proof to prove that I violated this law. Now, he said at the scene that he clocked me at 91 miles an hour. He wrote the ticket for 92 miles an hour. There's no proof other than him just saying, yeah, this is what I saw. When he pulled me over, I had never passed him. I was doing 68 miles an hour when he pulled me over.
All right,
There's no way. I wasn't even behind him. He was driving illegally in the left lane.
All right, sir. So first of all, 91 versus 92 is a moot point. You would get the same But I'm just telling you, in his police report, it doesn't state anywhere that he said you were going 91. He has 92 and a posted 70. That's all he has. So I don't know if the recollection is different. I don't know if he said 91, but he meant 92. It's a moot point. It really doesn't matter. What exists is a police report. It says you're going 92 and a 70. This is valid. It's a public record. It's a business record from the Washington State Patrol. That is a printout, essentially, of the speed that you were going. So did you get a copy of this police report?
No, I have not. I wasn't furnished anything that I was asked for other than the subpoena for the officer.
Okay. Well, it's not the court's responsibility to provide you with any of that information, sir. You wrote general correspondence of what you wanted to do. You got the subpoena out to get Trooper Alcock here. But other than that, we did not need to present you anything else. You needed to write your own legal documentation to request that.
Okay. Well, and I apologize I didn't. But so I asked him, does he have proof? And the answer is no. Right?
The proof is he answered that he observed you personally, personal observation. He wrote a police report, and I do have certification pursuant to IRLJ 6.6, which is a public record that you can find on the Washington State Patrol website that says that the specific radar that he used was calibrated, reliable, and accurate within the last 2 years.
Fair enough, but I still don't understand how he can. Where is it showing my vehicle doing that speed? You know what I mean? Like, there's
used a radar that has been certified by the state.
Okay,
and he's saying that he saw you, sir. It's your word versus his.
He said in his ticket that he saw a black truck going 91 miles an hour. I was driving a blue truck. He's claiming he saw me while he was a mile ahead of me. He's claiming he saw a black truck in his rear view mirror and has no proof of my blue truck doing 91 miles an hour other than he says that it was. And so this truck, by the way, is not actually mine. It went back to the dealership. So all I'd be able to do is show you the proof of the color of the truck doesn't match his ticket.
All right. Is your truck blue?
Yes.
Okay. I have right here that, let's see. Okay. A black is yours, a Ford F-150 pickup.
It was a Ford F-150, yes.
Does it have the vehicle license plate number of A0872331?
He used that after he pulled me over. I mean, how would he be able to see that to pull me? This is my point, right? There's many Ford F-150s. All could be blue or black. He's saying that from behind, he clocked a black Ford F-150 doing 91 miles an hour. I was in the left lane doing 68 miles an hour in a blue truck. So
you were going below the speed limit, the safe speed limit.
I was, and that's in the report. I said that to him on the scene. That's another reason I asked for the subpoena of the body cam footage, because I specifically asked him why he was pulling me over when I was doing 68 miles an hour, and he said he clocked me at 91 behind him, and I said I don't believe that I was ever doing 91. And my other question to this would be, what if I was doing 89?
We're not doing subjective questions, sir. I have a full docket today. We're here to get to the point. We're not doing
my point is that I do not believe I was doing 91 or 92 miles an hour. The truck he claims he saw doing 91 or 92 miles an hour does not match the truck I was driving. Yeah, the license plate matches, I'm sure.
All right, sir. Thank you.
But there's no proof. And that's my point. There's no real proof that this was me doing.
Thank you, sir. I understood. Trooper Alcock, can you please speak to the difference in color of the car?
Yeah, apologies, Your Honor. So it was a dark blue Ford F-150 Lightning. When I initially observed the defendant weaving in and out of traffic behind me, I activated my rear radar.
I object to that, Your Honor. I was not weaving.
What is your basis for objection?
Because he's asserting I was weaving in and out of traffic.
He has personal knowledge.
This is where courtroom strategy becomes more important than emotion. Winning an argument isn't always about talking more. It's about knowing exactly what matters to the judge. Many people walk into court convinced they're prepared, only to realize they focused on the wrong things from the very beginning. The next few minutes reveal something that every driver, and honestly anyone who might ever end up in court, should pay attention to. Watch closely, because what happens next is the kind of lesson you don't forget.
I objected that because I was following the law by staying right, accepting to pass.
Overruled. Go ahead, Trooper Alcock.
So when I observed him weaving in and out of traffic behind me, that's when I initially exceeding the speed limit. That's when I activated my rear radar with using the central lane and obtained the speed rating of 92 miles an hour. Like I said, it was a dark blue Ford F-150 Lightning with very distinct grille style, which is how I knew it was his truck and observed him as he approached me in the center lane. Then he slowed down, and I moved to the center lane, and we played this kind of game where he refused to pass me. So that's why he's saying 68 miles an hour. So I had to move over to the right lane for him to eventually move by me, so I was able to physically pull him over.
Okay. And Trooper Alcock, were you able to view his license plate prior to pulling him over?
Yeah, it was a temporary tag since it was a new vehicle that was posted in the rear windshield of the truck.
Okay, thank you.
So I'm sorry if if it was posted in the rear of my truck and you saw it before you pulled me over and you pulled me over from the front. How did you see it in my rear window? You were in front of me the whole time. How did you see my license plate in my rear window that you just said you saw in my rear window?
To clarify, it was because after I moved over and you passed by me and I pulled in behind you to pull you over and initiate a traffic stop, at that time I was behind you. Then I turned my lights on, initiated a traffic stop, and called out my traffic stop to the radio dispatch as I normally would, including the temporary license plate on your truck.
Thank you. Anything additional?
Well, again, it appears that obviously the police get to just change their story and say whatever, right? No real proof here. His documents do not match the truck I was driving. He pulled me over. He just himself said that he answered your question saying that he saw my license plate before he pulled me over behind me and behind him. There's no proof, Your Honor, that I was doing 91 miles an hour or 92 miles an hour. There's no proof because I wasn't. I think he saw me driving as I should, which is to keep right except to pass. And that's Washington state law. It's posted everywhere. It says all vehicles are required to stay right except to pass. He was cruising in the left lane with a line of traffic, claiming I was weaving in and out. And there's no proof. And I think that, this is just another example of why you can't trust the police, because he's just constantly changing his story to match his illegal ticket and his illegal actions, his illegal driving.
Regardless of whether we're in a physical courtroom or not, we show respect to all individuals, especially law enforcement. I mean, they do a great job doing what they do. I understand your frustration, sir, but he appeared here on your behalf so that you could have the benefit of the doubt to question him. And, I appreciate his time that was spent here. So I'm sorry that you were frustrated, but we show respect to any individual subpoena, regardless of what their occupation is. Based on that information, I do find that there is sufficient information to find that you committed this. I will mitigate it down. I do find that there is enough personal observation, as testified by Trooper Alcock, that he did see your vehicle. He specifically was able to pinpoint your vehicle. He did address the difference in color. He said that it looked black due to the fact that it was a very dark blue. I do find that that is an understandable difference. I do find that he was able to identify your license plate prior to actually pulling you over. So that is different than what you said. He was able to see you weaving behind him, but then you pulled in front of him, which gave him sufficient time to be able to specifically identify your vehicle as the one that he saw behind him. I do understand that you said the 68 miles per hour. Trooper Alcock did testify that that is the speed that you went to after he was able to clock you at 92. I do find that 91 miles an hour, as what you believe he stated when he pulled you over, is a moot point. 91 to 92, it could have been a misstatement. I don't see anything in the police report stating anything that he said 91, but even if we do believe your statement, that difference is minuscule and has no merit on this matter. In addition, I do believe that this speed measuring device was sufficiently calibrated and certified pursuant to IRLJ 6.6. I did look up the speed measuring device on the Washington State Patrol website, and as such, I do find that it has a proper certification, which is accessible to all public if they so happen to look. Based on that information, I will once again go ahead, find this committed, mitigated. I will go ahead and drop down your amount, though, to $150. I saw your hand raised. If you would like to make any additional statements at this point, feel free, sir.
No, I'm gonna refrain.
All right, sir, that is your choice. You have 60 days to make this payment or pay and or enter a payment plan. You have the right.
Every courtroom teaches a lesson, and this one is no different. Whether you agreed with the final decision or not, cases like this show why preparation, patience, and knowing the rules can matter just as much as the facts themselves. We'd love to hear what you think. Did the court get it right? Or would you have ruled differently? Drop your opinion in the comments because we read them all. And if you enjoy real courtroom moments, surprising legal battles, and unforgettable judge reactions, make sure you subscribe to Court Watch USA and turn on the bell icon so you never miss our next case. Thanks for watching, and we'll see you in the next courtroom.
To appeal this ticket, if you would like to appeal this ticket.
I will appeal 100%.
Wonderful. You have that right. So you will need to file a notice of appeal with the district court clerk within 30 days from today. And you must also serve a copy of your notice of appeal on the prosecuting attorney or city attorney that is responsible for this jurisdiction. So once again, that'll be received to you. This will be sent to you at your Vancouver, Washington address. Thank you, Trooper Alcock. You are you're relieved from now being here. So thank you for your time here, sir.
Thank you, Your Honor.
All right. So Mr. Allen, you'll receive this information. Once again, the appealing information is on the bottom of your ticket. So you'll be able to understand how to go through that process, sir.